On this episode of Law Weekly, we focus on issues of bail, bail bonds, recognizance, and sureties. This issue became very topical against the background of the recent decision of Justice Okun Abang to remand Senator Ali Ndume in custody because he could not produce the defendants he stood surety for. My guest, Norrisin Quakers SAN, breaks down the issues involved. Also showing on the program, activities to kick off the International Day for the Elimination of Violence Against Women and the United Nations 16 Days of Activism Against Gender-Based Violence, plus a recap of some of the activities across the states from the judicial panels inquiring into police brutality and specifically abuses by the now disbanded Special Anti-Robbery Squad, SARS. Hello and welcome to the program. I am Shola Shieli. I took a short break to rest and that was great. And it's also great to be back on the show. And what an interesting time to be back. The last few days has got almost everyone buzzing about the propriety of detaining a man who stood surety after the defendant guaranteed jump bail. I'm talking about the remand of Senator Ali Ndume. He has now been granted bail pending the determination of his appeal. But here's a short report that captured what happened. On Monday, the 23rd of November, a federal high court sitting in Abuja ordered Senator Ali Ndume to be remanded at the Kuje Correctional Center for failing to produce the former chairman of the defunct pension tax team, Abdulrasheed Maina. Senator Ndume, who is representing Borno South, stood as surety for Maina, who is standing trial on an alleged money laundering charge. However, Maina has repeatedly failed to appear in court for the continuation of his trial. In a bench ruling delivered by Justice Okun Abang, the court ordered the senator's remand pending the fulfillment of his bail bond, which is a forfeiture of 500 million naira to the federal government. Although the development came as a shock to many Nigerians, a check by Law Weekly showed that there are a few cases in which judges have sent sureties to prison or declared them wanted. Before his transfer to Abuja, the same Justice Okun Abang, sitting as a judge of the Federal High Court Lagos in 2015, ordered the arrest and remand of one Adeleye Oduniyi, who stood surety for Victor Bano, a dismissed police officer. Justice Abang ordered that Oduniyi should be remanded in prison custody after the prosecutor, Mr. Justin Enang, told the court that the accused had jumped bail and was still at large. 3 years ago, in October 2017, Justice Akim Oshodi of the Lagos High Court had ordered the remand of one Olorunmonu Olorunfemi, who stood surety for one Nonso Anigbogu, who was to be arraigned for a criminal offense to the tune of 16 million naira. Anigbogu, however, jumped the administrative bail granted him by the EFCC, thereby leading to the arrest, prosecution and remand of Olorunfemi. In another more popular case 2 years ago, on November 14, 2018, Justice Binta Nyako of the Federal High Court in Abuja gave Senator Yinaya Abaribe and two other sureties 2 months within which to pay a 100 million naira bond each due to their inability to produce the leader of the indigenous people of Biafra, Nnamdi Kanu. The ultimatum lapsed on January 14, 2019, and there was no indication that they paid. Rather, the senator and the two other sureties filed separate appeals against the order. These cases have raised concerns and questions about the processes involved in the granting of bail to suspects and defendants in criminal matters, the fate of sureties, and the legal remedies open to them. I sat down with a senior advocate of Nigeria, Norrisin Quakers, to try to answer some of the questions thrown up.
Well, quite frankly, the law on this is very clear, it's very apt. When a surety stands for a defendant or accused person, the condition usually is that any time the accused person or the defendant is needed in court, he will be produced. Now, in standing suretyship, there are certain things that the surety is expected to do. Part of it is to pledge assets. It could be a landed property, it could be money. Now, the idea behind that is that if for any reason the defendant is not available, it forfeits the pledged assets to the states. Now, can a surety be remanded in prison custody for failing to produce a defendant? The answer to that is no. There's even a decided authority on that. I think it's the case of Ekwagu and DPP. It was a case decided in Lagos. But there are instances when a surety can actually be remanded in prison custody if the court is unable to get the funds that has been pledged, or where the surety is also seen to be complicit or involved in some criminal conspiracy. In other words, knew about the fact that the defendant will abscond, jump bail. So in other words, if that element of conspiracy can be established, a surety can be remanded in prison custody.
So it won't matter the property that you have used?
It won't matter the property that you have used. So long as what you have pledged is realizable, there's something called forfeiture proceedings. Once the defendant jumps bail, the law is that the prosecutor must initiate immediately revocation of bail and start the process of forfeiture by also exhibiting the bail bond, or the bond that was pledged by the surety. Only then, and like I keep saying, the law is not an orphan. The law, there are provisions of the Criminal Justice Act that covers the field. There are also decided authorities on this issue. So it is indeed out of place to sentence a surety to prison for failure to produce. Again, it will also depend on the terms of the bail granted by the court. If the terms of the bail granted by the court has that provision that if you fail to produce the defendant or the accused person, you go to prison. But that is not here nor there, because this issue has actually been laid to rest. Again, a surety can also decide to be discharged from the suretyship. That's something that I think Senator Eyinaya Baribe has done. The law allows you to do that. I think Section 177 of the Criminal Justice Act. You can go to court to simply say you be discharged for, if for any reason you suspect that the defendant might likely jump bail or not be available. So you move ahead of time. The law allows you to do that. When that happens, the bail will be revoked, and then the accused person will then be rearrested. You can't go to court or the court to discharge you after the fact has now emerged that the defendant has jumped bail. But you can do that prior to that time. But the only other thing you can do, for instance, if you challenge the issue that you were never informed that the defendant has jumped bail, if that reason is tenable, the court will not go after your asset. But there must be proof that you have been summoned to the court to produce the defendant. It is that failure to produce the defendant that now leads to your assets being forfeited. That's what he says. That's what the law says. And the law on this is very apt.
With this whole Senator Ndume issue, there are those who have also brought in the issue with Senator Abaribe and, similar circumstances. Can you distinguish for us the difference between both cases?
Now, the difference there is, in the case of Senator Abaribe, he went to court quite early and filed an application that he be discharged from his suretyship. And that is before he was notified that the defendant that he stood surety for had jumped bail. In the case of Senator Ndume, he was summoned to appear before the court and to produce the defendant. And he got to court only to realize that the defendant was nowhere to be found. He was given ample opportunity and time to produce the defendant in court. And since he was unable to, the court, ordinarily, the court should have forfeited his assets, having been confronted with that fact, but not for him to be confined to prison. That's my own understanding of what the law is.
Let's talk about the different types of bail. And are there any conditions under which you pay for bail?
Bail is both constitutional and statutory. Section 35 sub 4 is apt on that. Statutory in the sense that it's also provided for in the Criminal Justice Act, I think from section 158 to about section 188. And then also section 30 to about 33 of the Criminal Justice Act 2015, federal enactment. Now, statutory in the sense that anybody who is arrested at a police station, particularly without a warrant, is entitled to bail. And if you're kept beyond the statutory period of 48 hours, you can go to court to seek enforcement of your fundamental right. And when that happens, section 35 sub 4 now kicks in. The court is duty bound to grant you bail either conditionally or on conditions. Once you fulfill those conditions, you're allowed to go. But at the station, bail is free. But we know that legally speaking, it is free. But in practice, it is not. You're made to pay. And sometimes even the officers on duty give excuses that the bail bond that you're given to fill or sign they have to run copies and they don't have enough copies. So you're made to pay for that. You're made to pay for electricity. You're made to pay for a number of things. So even though it is free, they make you pay for services that they ought to render to you statutorily. Bail, like we say, is a discretionary power vested in the court. There are a number of factors that are taken into consideration before you grant bail. One of such factors is the nature of the offense, the severity of the offense. The other is the criminal record of the defendant who is applying for bail. The other part again that you also look at is there a possibility or likelihood that this same person might influence the collation of evidence, might intimidate witnesses, might make it difficult for the court to dispense justice. Now, these are some of the considerations before a bail, and then there's also the aspect of flight risk. If you grant bail to a particular person, is there a possibility that he will not be physically present for his trial? So these are some of the considerations why bail can be refused.
The argument that when a defendant is a flight risk, can that be justification for what Justice Okun Abang did in this case? The Senator Ali Ndumek's case?
Not necessarily. You know, before you grant bail, in fact, with the issue you have raised about a defendant being a flight risk, is one of the reasons why bail ordinarily should not be granted to a defendant. So in other words, the fact must be before the court. It must be argued, and that fact must be placed. It's not what is conjectured. It must be a fact that is before the court, that a defendant is a flight risk. You remember I started by saying that there are no more factors that the court will take into consideration. One of it is this issue that there's a likelihood that this defendant will abscond. Two, there's also a likelihood that this defendant would distort, interfere with investigation, will interfere with the proceedings. Now, once you look at all of this, and you also look at the severity again of the offense, does he have a criminal record? That's also another factor. So when you consider all of these factors, and they are all in the affirmative, what do you do as a judge? You refuse. No court is duty bound to uphold an application or favorably disposed to an application for bail. Once you look at the factors and you feel that this is a defendant that should not be granted bail, he will not be granted bail. Talk less of giving a conditional bail to the point where sureties are being invited. Once you bring in sureties, once those conditions have been met and fulfilled, the defendant is allowed to walk away. In fact, in one particular instance, the surety died. What did the court do? When that fact came to the court, the bail was revoked and the defendant was arrested. Where a surety also dies after he stood surety for a defendant, the law on that is also that you go after the estate, except where the executors or the testators of the executors of the will or the administrator of the estate now decide that no, we will not allow this to continue, and then under section 177 filed to withdraw the surety, to be discharged from the suretyship. I mean, there are instances. The law is never an orphan. There are many provisions in our act that covers the field.
One complaint I have heard from some lawyers and a lot of defendants is that judges sometimes make bail conditions so stringent, so much so that sometimes it is almost nearly impossible to fulfill. And those people who make that argument say perhaps it's time to stop leaving bail decisions at the discretion of the judge, but to instead have written guidelines for the same.
You know, there's nothing like leaving it entirely at the discretion of the court. Once those conditions have been satisfied and met, if a high court, or a trial court, or even magistrate court, let me start first with the magistrate court, because there's also an appellate process that the law recognizes. If a magistrate court denies a defendant bail when those conditions have been met, you can appeal to the high court. The high court will review what has been said by the magistrate court and grant you bail. If the high court refuses to grant bail as a court of first instance, you can appeal to the Court of Appeal. The Court of Appeal will look at fact. Most of the cases that we always cite and we refer to were decisions that arose either from the magistrate court or from the high court that the appellate court were able to review and then eventually granted the defendant bail. So though it's discretionary, and you recall that we always say that discretion must be exercised judicially and judiciously. In other words, you have to guide yourself based on the law. What does the law say? The law has already given conditions for the granting of bail. the requirement for the granting of bail. So if you have looked at those conditions and you're satisfied that a defendant who has brought an application for bail has met those conditions, you can grant. For instance, bail can also be granted based on medical grounds. There's also an aspect of variation of bail. If the court has granted you bail and the terms are onerous, you can go back to that same court to review the conditions attached. So the law on this is very clear. Then there are a number of cases. It's well settled. No court can deny you bail in perpetuity. In other words, if court A denies you bail, you can go to the appeal court to ask for. Now, there's also another flip side which we lawyers also look at. If a particular judge who is seized of a matter denies bail and the judge is transferred to another court, you can bring that same application before the new judge, because the trial is to start de novo. The new judge will consider the facts and grant you bail. So it's clear. If he refuses, then you go to court of appeal. So there's a procedure that is in place, and you can't leapfrog that process.
Welcome back. November 25th is celebrated as the International Day for the Elimination of Violence Against Women, and from November 26th is the United Nations 16 Days of Activism Against Gender-Based Violence, which will end on December 10. To commemorate the occasion, President Muhammadu Buhari and some state governors highlighted measures that have been put in place at various levels to curb sexual and gender-based violence, which particularly increased during the lockdown measures introduced to check the COVID-19 pandemic.
Representatives of women across the country, led by the Minister of Women Affairs, Dame Pauline Talon, paid a courtesy call on the President at the State House in Abuja. President Muhammadu Buhari is conferred with the He for She Award, the United Nations Global Solidarity Movement for Gender Equality. After receiving the award, President Buhari speaks about the commitment of his administration to end violence against women and child marriage, while promising to do more to boost girl-child education in the country. He also speaks on the national gender policy and his commitment to sign a treaty in February 2021 at the African Union Summit to end violence against women. In Lagos, the state governor, Babajide Sanwo-Olu, promised to ensure that no offender indicted in reported cases of rape and gender-based violence goes scot-free. The governor gave the assurance when he received a 54-page compendium on sexual and gender-based violence, compiled by the Stakeholders Committee set up by the First Lady, Ibijoke, to give recommendations on how the fight against the crime could be won. He also said the state government would be prioritizing budgetary allocations to the Ministry of Justice for the acceleration of offenders' prosecution, while also supporting government agencies working in the areas of rehabilitation and integration of victims. Meanwhile, the wife of the governor has joined other stakeholders in a walk organized by the Egbeda and Isheri Dimu community to declare their community a sexual and gender-based violence-free area. At the end of the walk, the First Lady unveiled a signpost at the location. In Ekiti State, the wife of the governor, Bisi Fayemi, has been making moves to bridge the gap between women in high offices and those at the grassroots to further enhance proper communication and empowerment. To this end, a special women empowerment initiative tagged All Women has been launched by the governor's wife. Mrs. Fayemi equally inaugurates gender-based violence committees for all local governments in the state, which will be coordinated by wives of council chairmen. In Niger State, North Central State, Nigeria, members of the Federation of the Female Lawyers, FIDA, the National Human Rights Commission, and other stakeholders organized a rally. While commending the signing into law of the Violence Against Persons law in the state, they emphasized that enforcement of the law is key. The National Human Rights Commission also used the opportunity to raise concerns over the increasing cases of rape and gender violence in the state, disclosing that at least 5 cases are reported to the Commission on a monthly basis. The Commission is, however, worried that most victims of rape and gender violence in the state do not report, giving perpetrators reason to continue with the crime. To address this, the Commission is partnering with other stakeholders to kickstart an advocacy to raise awareness on the menace of rape as part of activities to mark this year's 16 Days of Activism. In the northeast state of Adamawa, the government, through the support of the United Nations, said it will soon launch a DNA forensic laboratory to assist survivors of gender-based violence with obtaining justice. The State Commissioner for Women Affairs, Lami Patrick, who disclosed this during a media briefing to kickstart the 16-day activism aimed at ending violence against women and girls. The Adamawa State Coordinator of United Nations Population Fund puts the figure of out-of-school children in Nigeria at over 14 million, with more than 70% of them being female. Still in the northeast, in Yobe State, the National Human Rights Commission and other civil society groups staged a street walk in Damaturu, the state capital, to protest the increasing violence against women and children. The campaign was to also ensure essential services for survivors of the violence, focus on prevention and collection of data that can improve life-saving services for women and girls. In Abuja, the Federal Capital Territory, the National Human Rights Commission is appealing to persons whose rights have been or are being violated to report such cases and protect themselves. After embarking on a walk with other stakeholders, the Executive Secretary of the Commission, Tony Ojukwu, explains that the rights of all persons need to be protected, as some men also suffer from gender-based violence. In Imo State, southeast Nigeria, an association of women groups marked the event with a peaceful march around Owerri, the Imo State capital. They called on the Imo State House of Assembly to, as a matter of urgency, expedite action on the passage on domestication of the Violence Against Persons Prohibited Bill, VAP, in order to protect women and end all forms of gender-based violence in the state. According to the International Federation of Women Lawyers, FIDA, and National Council for Women's Society, who were part of the protest march, Imo State is the only state in the southeast yet to domesticate the VAP law.
When do we want it? Now! And on the home stretch, we look at activities of the judicial panels across the states inquiring into police brutality and specifically abuses by the now disbanded Special Anti-Robbery Squad, SARS.
We begin with the news that the Lagos panel has again listened to the testimony of the Lekki Concession Company. The counsel to the NSAS protesters had asked the MD of the company questions about who manned the security cameras on the day the military showed up at the toll gate, as well as questions on the extent of loss of revenue to the company. This line of questioning did not, however, go down well with the counsel to the Lagos State government. In Enugu State, the Judicial Panel of Inquiry has received 45 petitions from members of the public. According to the chairman of the panel, Justice Kingsley Ude, 15 out of the 45 have been called with dates issued for their hearing. He also explained that the Bar Association in Enugu has agreed to provide pro bono services to any of the petitioners who cannot afford a lawyer. In Ebonyi State, the Judicial Panel of Inquiry has also confirmed that it has received petitions from citizens who say they have been unjustly treated by men of the Special Anti-Robbery Squad, SARS. One of the petitioners, a lawyer, Francis Chibueze, recounted how officers attached to the anti-robbery squad allegedly brutalized him on the 20th of April 2020, a situation which he says has led to his loss of a regular income. In Ekiti State, the Judicial Panel of Inquiry has recommended a 150,000 naira compensation to a petitioner, Mr. Adaramola Abiodun Olushola. The chairman of the panel, Justice Cornelius Akintayo, who gave the recommendation during a sitting of the panel in Ado-Ekiti, said that the recommended sum will assist the petitioner in putting his car back on the road by way of repairs. The complainant had stated in his evidence that his car was vandalized by hoodlums hoodlums, where he parked it by the roadside during the NSAS protest on October 19, 2020.
And here's where we adjourn till next week. Don't forget that you can watch again this episode of the program and past episodes on our YouTube channel. I'm Shola Shoyeli. Thank you for watching.